Bismillah ar-Rahman ar-Rahim. September 11, 2021, we are starting a series of legal discourse on Afghanistan under the lens of international law. CLLB, in collaboration with IRS Institute of Regional Studies, Islamabad, is hosting the series. The entire series will only be focused on international law, its significance and its applicability with reference to Afghanistan, and the role of the international community in ensuring global peace and regional security. My name is Dilawar Khan. I'm the Executive Director of CLLB. Let me introduce the panelists for today's discussion. We have a distinguished panelist of lawyers today, all based in Peshawar. So I have Mr. Shoaib. He is a lecturer of law at Edwards College, Peshawar. We have Mohsin Ali Turk, who is a former district and session judge and now a practicing lawyer based in Peshawar. I have Mr. Lawangeen Khan, who is a practicing lawyer, and all of them, we are very proud to be the faculty of the CLLB as well. I welcome all of you. Thank you very much for joining us today on this highly important discussion, and I look forward to hearing from you the international perspectives vis-a-vis Afghanistan. Before I go into the discussions, into the detailed discussions, I would like to come to Mr. Mohsin first, and I would like to have your opinion on what is the significance of the United Nations Security Council resolutions in maintaining global peace, specifically speaking of resolution 1267, 1526, 1988 and 2557.
Thank you. So, maintaining global peace and ensuring global peace is the mandate of United Nations Security Council provided to it by Chapter 7 of the UN Charter. So, under Chapter 7 there are three main instances in which the Security Council can intervene, where there is a threat to global peace, where there is a breach of peace, and when there is any act of aggression by one state against the other. So, in these three situations, United Security Council intervenes, and that intervention is in two kinds. It's either in soft shapes or it's in shape of coercive measures against the states that are doing aggression against the other states. So, the resolution 1267 and others, these resolutions are related to the situations in Afghanistan, where there was terrorism in Afghanistan. So, in these resolution 1267, for example, it provided for listing of persons, individuals and organizations which were involved in terrorist activities. The resolution then provided for certain sanctions, and then the sanction mechanism for imposing those sanctions against the organizations and the individuals. It provided for sanctions such as the trade and the arms embargoes, such as the freezing of assets, and many others. These sanctions were provided by these Security Council resolutions. Subsequently, when United States attacked on Afghanistan in 2001, so in November 2001, there was another resolution of the United Nations Security Council 1378, and that resolution provided for peacekeeping. Peacekeeping and peace enforcement is yet another main function of the UN Security Council under Chapter 7 of the Charter.
Okay, thank you very much. Mr. Mohsin, you have raised really key important points. September 11, 2001, World Trade Center happens. October 7, the US forces come to Afghanistan. 14th November, the UN resolution of allowing the coalition and other countries, and then 21st November. So, looking at the topic, Mr. Shoaib, enlighten us with your knowledge about the points which Mr. Mohsin earlier mentioned of the persons and organizations listed on the banned entity and under the UN resolutions as persons who are banned for certain activities.
First of all, thank you for having me. Now, as Mr. Mohsin has rightly pointed out, the implication of the UN resolution, specifically Resolution 1267. Now, we see historically the role of United Nations Security Council has been with relation to the states by and large under the notion of peace and security of the world. Now, we have basically entered into an era where the approach of international law based on states alone is with passage of time evolving at a very fast pace. So the actors which are not states, which could be non-state actors, certain entities, organizations, groups and individuals are basically finding their ways to become more relevant under international law. This particular resolution, Resolution 1267, specifically deals this notion or this growing sense of evolution in international law, where the United Nations Security Council Sanction Committee specifically dealt a group which was not a government in their eyes, which was not even a state. So how would we assure that an entity which is not a state can be obliged to follow the grounds which basically this resolution was talking about? And we see this sense of this widening gap between the theory and the practice in case of Qadi and al-Barakat. Now, the UN Security Council resolution specifies this particular fact that anyone who is basically associated with Taliban or Al-Qaeda, their assets will be freezed. This also invites the application of human rights law to a certain degree, because the people who were basically enlisted in that under the sanction regime were said to have not been provided fair trial, redressal. No, all these things basically started legal debate in Europe, because Mr. Qadi was a Saudi resident whose assets were in Sweden. The question was whether European Union was obliged to basically enforce the UN Security Council resolution within its jurisdiction. Now, eventually, first, it basically started with, we can say, where they basically went on to challenge their enlisting under the court of first instance in general court. Now, their approach was not basically given a lot of consideration, because we should also remember that the European Union basically made this resolution as part of their system. International law does become part of European Union to a certain degree. But the European Court of Justice adopted an approach which was slightly based on the concept of fundamental rights. It did not basically objected the United Nations Security Council's ability to pass a resolution on a subject matter. This was not their domain. But they said if there is a resolution which is basically finding a way, or which is transgressing the notion of fundamental rights, then this is where it will become a matter of monoism and dualism, which are two very important segments of international law.
Yes, Shoaib, you have rightly pointed out the implications and the complications. And this brings me to a very, one could say that, a question that needs Mr. Lawangeen more clarity. On 14 out of 33 proposed cabinet members by the Taliban, 14 out of them are on the UN list. What do you think of this situation? How this is going to unfold?
I believe that cases like Qadi and al-Barakat wouldn't have arose at the first instance if the UNSC had actually duly complied with the international human rights law. It's a stark contrast when you look at the UDHR, specifically Articles 7, 8, 10 and 17, which says that each person has to be granted equal rights, equal application of the law, and no person shall be deprived of his property, his finances, his funds without due process. Now, considering the resolutions that you and Mr. Shoaib so rightly spoke of, they are in stark contrast of the UDHR. Now, in such a situation where Afghanistan is placed at such a back foot, where it is such a weak state, where it is getting out of the grips of war, now we'd be making them lose faith in the international community by imposing such unilateral restrictions, where they don't have the opportunity to challenge them, where they don't have the opportunity to actually put forth their views upon it, challenge that decision. And in that light, if we do not adhere to the international human rights law, then I feel that such resolutions would not be effective, and cases like Qadi and Al-Barakat would be rising off and on, and more often than less.
That's right. Do we have a mechanism of delisting? And this is a question for all the panelists. If somebody is on the list, do you have any examples from the national legislation or international regime? So once you're in the list, there has to be a mechanism of delisting.
Yes, well, there is not a specific mechanism that applies to different people, but you can actually get delisted of the United States, the United Nations Security Council. So it's actually Article 14 of the UNSC Resolution 1267, which was basically imposed to achieve certain aims, which was basically creating sanctions upon Taliban funds. So Article 14 says that if the Taliban makes compliance, if those elements against whom that sanction was raised makes compliance of the obligations that it is due under international law, then such sanctions or such listings will have to be lifted. So I feel that the conditions such as adhering to the rule of law, financial transparency, and basically granting each and every ethnicity their rights, adherence to an international human rights law, these would be the conditions and the you could say the impositions that are placed upon the Taliban to achieve, so that they can be delisted or removed from the sanctions list of the United Nations.
Knowing the commitments or the conditions placed under international law, Mr. Turk, what do you think that what is that Taliban right now would be evaluating, and what is that the new regime would like to consider the conditions imposed under international law? How are they going to translate those into their domestic legislative mechanism?
For the new Taliban regime, it's a very challenging situation. Presently, after the takeover of the Taliban in Afghanistan, the regime is silent about any constitutional mechanism or any constitutional arrangement within Afghanistan. Presently, Afghanistan is being run without any constitution. So the Taliban regime will, the first ever step they will have to take is to return to constitutionalism. So they will have to either to adopt the constitution back, which practically has been abrogated. They are silent on the constitution. They have not said anything whether the constitution exists or whether it abrogates, but practically it has been abrogated. And if we see the new cabinet that has been announced by the Taliban regime, so that is not in accordance with the constitution of Afghanistan of 2004. In that constitution, there is no room for the office of prime minister or deputy prime minister. So practically this constitution has been abrogated. So the first ever step that Taliban are supposed to take is to return to constitutionalism. They are supposed to enforce fundamental rights. They are supposed to guarantee the basic human rights and the fundamental rights of the citizens, particularly the equality right and the right of women and vulnerable segments of the community, which the world is seriously focusing on, and even the recognition of the Taliban government that is attached or that is conditional to their human rights situation. Then they will have to frame an inclusive government. If we see the present government, there is no woman in that government. There is no one from the minority or the opposition parties in that government. So they have to form an inclusive government in Afghanistan. And then the most important is that they will have to comply with all the resolution of the United Nations Security Councils related to combating terrorism and terror financing and things like this.
Mr. Shoaib, taking the lead from this answer that Ashraf Ghani has not left the government in the constitutional way as per the constitution of 2004 Afghanistan. How do you see the notion of recognition with reference to Afghanistan under the international law?
As far as the law of recognition is concerned, there are basically two areas in that. One with reference to the recognition of a state, and the other is with reference to the recognition of a government. Now, Afghanistan as a state is here and it is going to be here. I mean, its territorial jurisdiction is pretty much the same even when we talk about the first Soviet invasion in 1979. Afterwards, the territorial jurisdiction has not changed, or the concerned parties have not made any effort to actually change that. This brings us to the second part, which is with reference to the recognition of a government. Now, I know it is a very legal question, but when we talk about recognition of a government, it can invite a lot of political controversy to a certain level as well, because states which are seen as sovereign entities under international law cannot be compelled to undertake an action which is against their policies, their state policies. Yet, there are basically two broad criteria available for that. One criteria is basically based on constitutive theory of recognition, and the other is declaratory theory of recognition. This constitutive theory of recognition basically points out to the fact that the states or the governments of the states would gain legitimacy only when they are recognized by other states. Now, the second view is that basically the recognition of a government by other governments is only a formal acknowledgement of a reality which has already displayed its power on the ground. Now, this view basically says that the legitimacy of any government should not be determined by outside factors or by the external powers. If they can exercise effective control, they can have laws, they can execute those laws, and basically they can protect the jurisdiction of their borders, then probably it means that they are a government.
The United Nations ensures one thing, and that is that any member who is part of the United Nations plays its role, so that to respect and ensure respect of the international instruments and the obligations upon the states. So it is, we are living in an era where many challenges that the world faces are taken as a shared responsibility, that it's not only one state's responsibility to look after a particular issue. International global peace, prosperity, global security, fighting, combating international terrorism, financial frauds, these have emerged in the recent years as some of the challenges where there are global efforts. So Afghanistan is again a case scenario where the international community has to come forward and play the role, because 20 years we have seen that the force has not worked, and it is very evident from the events that we have seen in the last 1 month. So if force has not worked, what are the other options, and what kind of responsibilities under international law it places on the rest of the international community, other countries, but especially on the neighbors?
If we do not have recourse to armed conflict, then the only way that we can move forward is through amicable resolution. Now, having said that, all stakeholders need to play their positive part in this process. Now, obviously, the ones that will be most affected from Afghanistan, the ones that will have the direct impact of Afghanistan's position, will be the ones that are the neighboring states. Now, it's a territorial question, and as Mr. Shoaib pointed out, Afghanistan is not changing its territorial limits, and neither is it going to be territorially placed in a different place. Its neighbors are not changing, and Afghanistan is not changing. Now, the neighbors will need to, and let's say for instance Pakistan has been playing a very supportive role for the past you could say 4 decades, and hopefully it will do so in the future in Afghanistan's betterment and for the betterment of the whole territorial area. Now, having said that, we need to ensure that Afghanistan is in a position where it does not affect the neighboring states and where Afghanistan is not left at a back foot. Pakistan has entered into trade agreements with Afghanistan, which imposes obligations upon Pakistan to give Afghanistan its due, because it is a landlocked country, and as such basically placing embargoes upon it, closing off its borders would not be up to the standards of the international community or the international law. And now there are other major stakeholders, there are major players in the world that also might have an interest in Afghanistan, such as permanent members of the UNSC, Russia and China. They have trade aims, they have trade purposes, and for that Afghanistan is in such a territorial area, or it's in such a place that having Afghanistan not on board will be a problem for all of these neighboring states, and obviously the neighboring states have a say or a play in the general international community. So if they are not in consonance with the views of the international community and the ones that are directly affected from Afghanistan, we cannot reach a settled conclusion. So it is all these stakeholders, all these states that have actually a direct interest, or through the UNSC, that have to play their role in getting the Afghanistan new regime and the relevant stakeholders on one platform and bringing them to an amicable conclusion.
Thank you very much. Thank you very much, Mr. Lawangeen, Mr. Mohsin Ali Turk, and Mr. Mohammad Shoaib. So the main takeaway from today's discussion that we have taken, that both Afghanistan and the international community under the international law have obligations and responsibilities to perform. The Afghanistan government has to ensure that within their constitutional limits, they have to make sure that the international instruments and the international obligations and responsibilities are fully respected. And the international community vis-a-vis Afghanistan has to realize that it's a new government. They may not be very well aware with the international instruments and the obligations. They need to be taken on board so that the many challenges that Afghanistan will face in understanding the international obligations under the international law, neighbor countries such as Pakistan, friendly countries and many states of the world needs to come forward and assist Afghanistan in making sure that the international instruments are respected to ensure not only international, regional, but local security and peace for Afghanistan and the rest of the world, so that we do not see again September 11, 2001, and we hope that the international peace and security is promoted and dialogue and international law is given an opportunity to serve the purposes of peace and security.